Okay, and we are live. Thanks everybody for patiently waiting. I hope that people waited. There were some technical difficulties, and just to reduce dependency on one platform, I tried to connect. We are Facebook Live. Apparently, they support just mobile browsing, so we're back on desktop and StreamYard, which is a good platform. Sometimes it's glitchy, but anyway, we have. TMP here, all the way from Las Vegas, Nevada, and previous guest, Rabbi Jacob Belinsky, with an update. The advertised topic is the new federal complaint that TMP filed in his local Nevada federal court. So we'll probably start with that. And then Jacob is a very proficient, very professional, I would say, even pro se litigant, will provide an update on his case. And thanks everybody who joined his sentencing hearing that I advertise using whatever humble reach I have. So, Matthew, please tell us. I
Yes.
made I shared your post. Actually, it got a lot of shares. I saw that many people read it. Very interesting, very brave of you, of course, to go against your judge. Everything is legal. So please, please tell us what's going on.
Well, it's thank you. I got to say the response to the article has been overwhelming, and I just really was impressed and surprised, I guess, at how many people, how many times it's been shared, and how many people have seen it. But and I did take some notes here that I wanted to talk about this time. I'm trying to be semi-prepared, but the basically this is all about cameras in the courtroom. And everywhere you hear people talking about cameras in the courtroom. And the big thing is people want cameras in the courtroom because there's this perception that cameras will protect the litigants. That if the camera eye is somehow focused on the judge, then the judge will be less likely to play games around. Now, I don't know how true that is because I think the more wily judges will just kind of cheat you in a more subtle fashion. But I mean, if you want to keep judges honest, we need to get rid of the whole judicial immunity. That's the only real way to keep judges honest, so to speak. But that fact notwithstanding, there's a huge movement towards cameras in the courtroom because, of course, most places don't have cameras in the courtroom. Now, Nevada, ironically, does. So if you want to, you have a court hearing in family court and you want to review it, what did the judge say or what did the other party say, you can just order like a little thumb drive for a nominal charge of like $5 or something silly like that. And but nevertheless, there's this huge, cry going on. Everybody wants cameras in the courtroom. Well, what they've done in Nevada, well, in Las Vegas actually, where anything goes, they've decided that or I guess the family court cabal, that would be the pronoun they. It appears the family court cabal wants to control media perceptions. They want to control perceptions of the judiciary, and they want to control perceptions of, how the court system is run and that kind of thing. And so to do it, they have a guy who I believe is in large part by the family court cabal. And they've really used the cameras to weaponize uh, the whole situation. The cameras have become weapons because what happens is a lot of people get cheated in family court. And it's not, a one off when you hear somebody complaining about my judge cheated me, my judge screwed me over, I can't see that's going on everywhere. Thousands of people are crying out on Facebook. They're anywhere someone will listen, they're talking about it. And I believe that the family court practitioners and other members of the family court cabal, they don't want to hear people crying out. They don't want to hear people complaining about judges. They don't want to hear due process and these other, vilified, terminology. So what they do is they've used the cameras in a way that people wouldn't expect, I think. They're using cameras to get in the courtroom so they can film your proceeding and then put it online and humiliate everybody and denigrate everybody and give a false perception of the proceeding with false narratives that go with it. And then inevitably you see all the members of the peanut gallery who come to kibitz on the various posts, right? And you'll see people who I believe are all members of family court. They may be paralegals, they may be social workers, but they will flock to these sites to make fun of the parents who are in the video. And the reason they do this, again, is to silence the parents. Because if somebody like me speaks out, they don't want me speaking out. So they have, paralegals and other members of the legal community who go online and say, look at this guy. He's crazy. He's this, he's that, he's the other thing. And they do it with the specific intent to humiliate and denigrate and defame and all of those wonderful things. And it's really out of control. And I got to say, it's a really sad and dismal commentary on the state of mankind that somebody could lose a child in the first place in family court. It's just unbelievable to me still that they take children away. But not only would that happens, and then members of the legal community who work in these family court, law offices, they go online to mock these parents. Oh, look at you, you're an idiot, talking about due process, and you're crazy and you're vexatious, and same theme, violent, vexatious, crazy. And that's got to be debilitating. And there was recently a decision in the Nevada Supreme Court. Again, I had notes here, but it was a 4-3 decision. And this 4-3 decision came down about 2 months ago, I guess. And it basically says that there can be camera access in the courtroom. I don't think it's a real complete ruling because there's lots of questions left over. My personal take, and I did write this down here, is that when it comes to witnessing proceedings or auditing a court proceeding, I believe any member of the general public can walk into a courtroom and see what's going on. I think that's fundamental. The next level would be recording a proceeding. Can somebody walk into a courtroom and record the proceeding? I think the parties should have an inalienable right to do that. Okay. Whether third parties can do it, I have reservations whether third parties can record. And of course, the third tier would be commercial publication. The issue is, can a private person commercially publicize these videos, meaning take proceeding of Phillips versus Phillips, put it on YouTube, and then make money? Who owns the copyrights? I mean, there's some interesting issues here. And so when they had this ruling, I wish they had been more detailed, but I intend to litigate this area, and it's my intent to create law because I think this whole area of cameras in the courtroom is important, but they have to be careful to not allow predatory individuals to weaponize the cameras in the courtroom and to use those, cameras for purposes that, are not really aspirational, for lack of a better term. So that's my thought right there. But that's the background. And if I haven't bored everyone to tears yet, um, the lawsuit, in my case, what happened is the media reporter secretly submitted a media request. Now, when I say secretly, this news reporter, I'm presuming, just sent the paperwork to the departmental inbox for the judge to sign it. It's basically a request and a proposed order. Now, should the media person have notified the parties? Well, of course they should have. I think in the interest of fairness, they should have. And this news reporter has everyone's email address. And in fact, he's emailed the parties before. Why he chose not to email this time, or at least to CC everybody on the submission, I mean, that remains to be explained. But when the department received this media request, they have a duty, actually under Nevada law, to notify the parties. So as soon as the department receives a proposed order for media access, they must notify the parties. That didn't happen in my case. Also pursuant to California law, pursuant to Nevada law, when a media request is submitted, the judge shall consider, and I'm using the word shall because it's in the statute. It says the judge shall consider the right to privacy, the right to a fair trial, and some other things. And so it's my argument that the right to privacy is a constitutional right. There's no issue there. The right to a fair trial is also a constitutional right. So if my constitutional rights are at stake and the judge is going to consider an order that materially affects my constitutional rights, well, that triggers due process requirements at the 14th Amendment. And the court has to give the parties notice of the proceeding. They have to have an opportunity to be heard because the parties may wish to mount objections. They may wish to file affidavit testimony. They may wish to, I don't bring in witnesses. I suppose they could do all sorts of things. They have a right to make legal arguments, a right to create a record. But in my particular case, there was no ability to do that because the news reporter surreptitiously submitted the media request, and the department nor the judge ever notified the parties, and the judge adjudicated the matter and signed it in total secrecy, just like they used to do in the Star Chambers in back old merry old England. And I think it's enormously unfair. It's certainly a violation of due process. And so I filed a lawsuit under 42 USC 1983, and I'm seeking only injunctive relief. I'm suing the defendants as state actors and actually officials of the state of Nevada. Now, that would ordinarily trigger 11th Amendment immunity, but I'm proceeding on injunctive relief under Ex parte Young, which is a case from 1906 or 1908. But that's the legal theory, and those are the facts. And I'm actually real confident that I'm going to prevail because I don't think there are any defenses available to the defendants. Certainly, there's not going to be Rooker Feldman. There's not going to be younger abstention or any domestic proceeding exception. This is a clear cut violation of due process that has nothing whatever to do with family court. It has purely to do with the idea of, do the parties get notice of a hearing and opportunity to respond when their civil rights are at stake or on the chopping block or whatever it is. And so that's the case in a nutshell. Did I do it under 15 minutes?
Yes, you did. Thank you. Thank you very much. I think it was an excellent summary. I will also want to thank all the patient audience because we tried to connect before using the Facebook live stream feature, but we are back to StreamYard platform, which has some glitches. But we are being watched, so thanks everybody. Leon is very active from Australia. And Lena, I want to thank you. Actually, we are looking for somebody, and we had guests from other countries, but not from that area yet, not from Australia or New Zealand. So if you want to join the show at some point, let's just connect offline and schedule it. I know there's time difference, so thank you. He's saying I'm putting the transcripts here. Sorry, the comments here. The comments mention the transcript, so they're always wrong. And we'll get into that because we might have some different opinions in this topic, but he's saying the same thing is in Australia. We know it's everywhere. We had a guest from Europe, we have a guest from Canada, and if you, Leon, if you can join at some point, we'll have a guest from Australia. Yeah, being called a misogynist in family court was very funny. That's a separate topic. So we also had Jacob, but he had to drop off. Jacob had an update on his case. He's very proficient, very intelligent pro se litigant. So Jacob will get you on the show another time. I think there were some issues. You're actually he's here. So Jacob, he was patiently waiting before, so maybe we'll even hear an update from him as well. But anyway, Matthew, if I can summarize. So and we are not family court, right? So we can have a divergence of opinions, and we can have a healthy debate, some plurality right around the topic. So I'm a free speech absolutist. I think everything should be permitted. People can say whatever they want. Information should be generally available, and I'm an advocate, myself, for open courts. That being said, in your case, it's a constitutional question on which we are fully aligned. I read the decision that you mentioned, the decision of the Supreme Court of Nevada, and essentially what it did, if I recall correctly, is they decided to strike down a local rule that prevented access of the press to the family court proceedings, which was just a general, prohibition, right? And they left it to the discretion of the judge. So in any case, it remained a discretionary issue that in every particular case, upon a request made by an external party or one of the litigants, right, the judge may decide whether to open the case or allow
Yes.
press coverage, right? So fundamentally, it
Yes.
remained under the purview of the judge. So it's not an absolute opinion, it's not an absolute closing of the court, right? And as long as there is discretion
Right.
and there are parties who are affected, these parties have to be heard. This is fundamental due process principle, right? And that principle was violated in your case because, as you said, the motion itself was submitted without your knowledge. The decision was made without your knowledge, right? And this is so fundamental that it seems that you're completely justified in bringing this case up to the federal court. So kudos on doing that. I respectfully agree with you. I think that's something that the federal court needs to opine on. Whether in this particular case the proceeding need to be open, whether there's some unsightly or shadowy motives behind that, that's not part of the question. The question is if you are a party to the case
Sure.
and the judge has discretion, right? The discretion has to be informed, and you were not even provided the opportunity. I saw that you have additional defendants in your case. Can you maybe tell the audience why they are there and what?
Oh, yes, yes.
Mhm.
Well, the judge, I believe, is responsible for not initiating the notice to the parties and not giving them an opportunity to be heard. But state law in Nevada, I believe, contemplates the 14th Amendment notice and opportunity to be heard requirement, because pursuant to the Supreme Court rules, there's a specific requirement that the clerks shall notify the parties. And the clerks didn't notify the parties. And I just think, for better or worse, the clerks may be unaware of that obligation. And so that's why I'm also suing the county to train the clerks in the future. I'm not suing the clerks for money. I'm not alleging any, uh, malicious intent or that kind of wrongdoing, just simply that they need to be properly patted on how to handle a media request, and they need to be sensitive, I believe, to the Constitution. But let me say one thing about the case. I think you really understood that case really well, the way you synopsized it. But it really stands for the proposition, more than anything else, that if the judge is going to not allow camera access or not allow a member of the public to come in, well, that would implicate the First Amendment right to access the courts. So the good thing I like about this ruling is it recognizes there's a constitutional right to access the courts. Now, that having been said, well, what does that mean? It means before they can slam the courthouse door in somebody's face or reject camera access, they have to say, would this denial of camera access, the judge has to do this. They have to ask the question, would denial of camera access, is there a compelling reason to do this? Is there a compelling state interest? And if we're actually rejecting camera access or other access to the courtroom, is that denial narrowly tailored to effectuate a compelling governmental interest, what we know as the strict scrutiny test? Now, personally, I'm kind of, upset about this because I've been arguing for years we need strict scrutiny analysis in family court. Before the government can take away a constitutional right, including the right to parent, there must be strict scrutiny analysis. Is the taking of this parental right, is it narrowly tailored to effectuate a compelling governmental interest? What is that compelling governmental interest? Does the taking of my custodial rights actually further that interest? Is there any way to narrowly tailor this order as narrowly as possible? And finally, are there any less restrictive alternatives? This is the compelling state interest dance. And they don't do it in family court. Now, all of a sudden, they got to do it for the cameraman. I mean, how ironic. We as parents are begging for strict scrutiny to adjudicate our constitutional rights as the litigants, and then some camera guy comes along and complains about his First Amendment right, and they say, oh, my goodness, we need to do strict scrutiny analysis before we take away the cameraman's constitutional right. But when they took away Phillips' right, Phillips' custodial rights, no strict scrutiny analysis, no narrowly tailoring. They just, like Nazis, they came and took it away because they could. They did it forcibly and under threat of force. And it's a abhorrent thing. And I'm just hoping, trying to be a positive person, I'm hoping that this recent arrival of strict scrutiny at the courthouse door will enlighten these family court judges that they cannot be taking away custody. They can't impair your custodial rights. They can't terminate them. They can't abridge them in any fashion unless they first ask, why are we taking away this guy's rights? What is the compelling governmental interest in taking away his kid? And is this the most narrowly tailored way of doing it? And finally, is there any less restrictive alternative? And so that's, I guess I went over 15 minutes there, but
Because you covered another
that's,
topic, right? So,
yeah,
it's an excellent question, right? And I have a couple comments, if I may. And again, it's just we have an open debate here, and I see that people are chiming in. Dave comes from New Jersey. Thanks for joining. Derek is saying they don't care about any scrutiny, let alone strict scrutiny. I want to also acknowledge Leon is saying that I'm your go-to dad down under. So maybe we'll have a guest from Australia finally. So that's going to be interesting. Thanks everybody for watching. Now, what I want to say is that you know the fact that our rights are violated in terms of the procedural review, right, doesn't mean that the same violation needs to extend to other aspects of the case, right? So I agree with your argument. So if they apply strict scrutiny examination, right, to the question whether another party can access the court, right, court files and everything. It means that they need to extend everything, right, or the same approach to people who actually participate in the case. And with that, I agree. Right. What I'm saying is that you are a sophisticated litigant. You are capable to the most extent possible to defend your rights. Right. But what about other people who come into this horrendous chambers of horrors, right? And they're dismembered there, right? The only thing that's missing is just blood on the walls. It's complete, massacre. Assisting, chambers. There's no other word. Star chambers, whatever. So these people, they need the public's, supervision, right? The family courts need to be fundamentally open. Now, my fear, and that's I think that's what motivates so many people who fight for open courts, like James Kelly is doing in New York, is that once you open the sliver, the door for judicial discretion, they will abuse it as they do in many other aspects. So if you allow judges to close the courtrooms, they will close everything essentially, right? So then that's the question. But in your particular case, and I also agree with you fundamentally, without knowing the details of the case or particular people who are involved, right? And again, it's a general level discussion, but it's known that all dictatorship, right? They when they consolidate power, they don't want to face the public head on, right? They do it in a very sneaky, slimy fashion, and it stands to reason that the regime or different state regimes will try different approaches. So it can be that in Nevada they're trying that particular case, and they can be using people who are essentially controlled opposition, right, in order to promote the same nefarious goals that are behind this very clear consolidation of communist power through the family courts in so many aspects. So let's see if yeah, Jacob is saying this bar member. Jacob, you're coming in and out, so I'm trying to add you to the stage. But you are welcome to try to rejoin and give your update. So um, Matthew, one other question. So procedurally, your case has been filed. Is anything scheduled? Is there a way for the public to see the actual papers?
Yeah, I'm going to be posting them online. Right now, procedurally, the county council has accepted service of process on behalf of the defendants, and they
Hmm.
executed a waiver of service form, and so they've agreed to respond 60 days out. I'm not sure when 60 days is, but I think it's in June. So I don't expect hearing anything until June, but I will keep everyone updated. I think it's an important case, so
Yes,
there's
yes.
that.
Excellent. Okay, so we have Rabbi Jacob Belinsky, an excellent pro-se litigant. For those who don't know, it's his second time on our show. Jacob had a sentencing hearing that I shared, and it seems that it's been watched has been watched by people from across the country. So, what's your update, Jacob? Please tell us.
Can you hear me, everybody?
Yes.
Yeah.
Okay. So actually, just a point of correction, nobody actually got to hear it because they were having audio technical difficulties, allegedly.
I
And
know
I
that
want
many tried. I certainly shared it, and I saw that many people tried. Okay.
absolutely, and I appreciate you sharing it, Roman. I've gotten a lot of interest from your followers and people that are similarly situated.
Yeah, it's not on our end. It disappeared. The family court cabal is trying to disappear. It's only half a joke, right? But yes, let's see. Here, apologies, everyone. Technology, Jacob. Hopefully everything
I'm
is
not
That,
sure if
okay.
you can
yes.
hear me. I think I'm
Yeah.
being throttled by my internet. I might move to join a different time, perhaps. I can see
Yeah.
myself, but I can't
No,
hear
no,
you.
we see you. You just come in and out. So maybe just do it succinctly. Try to squeeze in before you are throttled in. Yeah, no, it's hard to hear you right now. You're kind of freezing. Okay, we'll wait until you come online. I'll read another comment from down under from Leon. He's saying, fellow respondents, the best bit of evidence I've been able to add to my affidavit, providing details whatever happened to myself and the family. Okay, so that's a practical advice. But we are actually I feel blessed that people from all over the world are coming to my humble page, which emphasizes the fact that we're dealing with international phenomenon, and it's governmental oppression through family courts in every country, every developed country that's part of essentially dismantle the family and part of the same globalist agenda. It's, those who have critical thinking skills see that. Um, Kelly's saying family courts are evil. She's from New York, and great female participation on my page. We are not. That's that's true because they once the government starts eating, they don't discriminate between segments, and everybody needs to understand. Um, I don't know. We are losing
Yeah.
Jacob, so it's not a pleasant experience for the audience. So maybe we'll just provide an update on a separate live stream. Um, but Matthew, back to the topic that we were covering. I just procedurally. So the class action that you filed with in California, right? You are still within the time
Yes.
frame for the appeal, right? So and that's something that
Yes.
you are
Well,
thinking.
what I did is, oh,
Hmm.
I'm sorry to interrupt. I was going to say, yesterday, my office had caused to be filed a notice of appeal in connection with the case, just to preserve our rights. If the appeal is not yet vested, meaning if it turns out that the order is not, it will uh, it will vest when the final judgment is actually entered and then the notice of entry of order on top of that. So we just wanted to make sure there's Mark. I see Mark. But no, we wanted to make sure we had protected our rights just out of an abundance of caution. But I don't think the decision is not yet final because all we have is a minute order, and the minute order is a very kind of terse ruling that says motion denied. It's the subject is right next to the verb, and there's not really much else other than that. And but we're expecting an order, so I guess when that finally comes out, and then when that's served, then that will trigger the operative date. So we'll definitely keep everybody posted. I think that the ruling was incorrect because I believe that Justice Ginsburg, her ruling from 1994 in the United States Supreme Court, I believe that's paramount to the Ninth Circuit. Now I know that's probably not an elaborate legal theory, but I was really surprised that the federal judge in Los Angeles, had relied on Ninth Circuit precedent as opposed to Supreme Court precedent, because they really do say two different things. And when there's, not really a conflict, but a disparity like that, a difference, then I think the Supreme Court precedent has to be controlling. And, I may be wrong, but I haven't seen an explanation that would convince me otherwise at this point. So for that reason, I'm uh, I'm dead set on appealing and prevailing ultimately in this case, because the facts are compelling, and there should be a remedy in this case. And I think again, plaintiffs are entitled to the relief demanded. But now I sound like I'm in court again. So
Yeah, that's I think part of the reason that people are watching. And again, we are grateful for everybody. Mark, thank you for joining all the way from California. Kelly and Leon are chiming in. So, yeah, I think we shouldn't lose sight of what's going on beyond the legal terms, right? Because we all know, at least that's my approach to what's going on, to analyzing the what we are experiencing, is that we're not facing a legal issue. We're facing an ideological / spiritual battle here. And the people who are trying to consolidate again the oppression, they're using the courts. It's lawfare. That's what's going on. And I made the post, actually inspired by an attorney who is fighting the what they call the quarantine camps legislation, or regulations promoted by Hochul, our local governor, that actually allow her to, or some unnamed bureaucrat, to put people in camps right when they declare the next pandemic or whatever they have planned for us. So she sued. She won the in the Supreme Court, the first court, but she lost in the appellate court, which ruled in just I think it was 4 judges, 5 judges. It's another bizarre thing here in New York. You can have 4 judges, which shows they never disagree, right? What happens if they split opinion 2 and 2? So it's always it can be an even number of judges, just unbelievable. So she lost. She now filed another appeal in the, which is essentially certiorari. Right? It's a leave to appeal in the highest court of New York. But why I'm telling all that, because she told a story about a local legislator here in New York who saw that his colleagues actually are in Albany are promoting, and Jacob again, are promoting legislation that I know is clearly unconstitutional, something like giving voting right to illegal, something like that. And he asked, he was a junior legislator then, how can you do that? And the answer was 5-1. 5-1. What does it mean? It will take you 5 years and $1 million to win your battle in court to prove that it's unconstitutional. In the meantime, right, it will prevail. So that's the same tactic that you just described, right? They deny you using some sort of pretense, just hoping that you will quit, you will give up, you will drop the case, right? In the meantime, that's the law of the land, at least that piece of the land that you are suing on. So it's the same slightly comic tactic, just live another day, catch me if you can, we'll legislate by fiat, by case, right? And you will suffer. The children will be, they know what they're doing is illegal. The children are alienated in the meantime. That's, they put in the stake in the ground, and that's the way it just continues. Jacob was on, and then he's off. I think that's just not gonna work this time. So, Matthew, you have anything else? We said it might be a shorter stream. I wanted to do it to show people New York is actually a beautiful state. If you go, especially if you go outside the city, I'm on Staten Island here. It's called the Green Belt. I don't know if people can see that, but it's getting closer to dark. But it's a hiking area.
Beautiful.
Yeah, I go hiking. That helps me cope with all this insanity of family court. Before that, I lived in Seattle, and Seattle is it's a rotten city, but you can drive 30 minutes and you are in the mountains, really high. So in terms of nature and outdoors, that's amazing. So that's my method of of dealing with this whole madness that's surround us. So I wanted to change the scenery a little bit, but. If nothing else, Matthew, maybe a couple sentences for to conclude the current hearing, and then we can win next time. And maybe just in short, Jacob has a more reliable connection because he has an important update. Rooker Feldman as well. So anything last?
Yeah, I was hoping that. Well, I wanted to hear that Rooker Feldman update. I was anxious, but I just want people to focus on when this issues of cameras in the courtroom come up. I think there has to be a three-tiered analysis with watching the proceedings, merely being present in the courtroom, and then a second level of recording those proceedings, and then finally the commercial publication. I think the commercial publication of court proceedings, that's a minefield in itself, and maybe we'll have to do a show on that one right there. So, but that's my story, and I'm sticking to it. So,
Excellent. Kelly, thank you. Thank you for saying thank you. Thank you for joining. Thanks everybody for watching. Thank you for those who will watch later on. That's important. We need to share. We need to show our faces, tell our stories, show our names. The tyrants are hiding. We are not hiding. We are doing everything peacefully and legally, strictly within the confines of the First Amendment. We have the right to criticize the government, to expose their stories, expose the tyranny, and that's what needs to be done. Matthew, thank you very much for your time today. Thanks everybody for watching, and we'll reconnect on the next live stream. Thanks everybody. Thanks.
thank you.
Bye-bye.